Hi, everyone, and welcome. I'm Veronica Vargas Stidvent, Executive Director of the Center for Women in Law. Welcome to the latest installment of our Perspective series, which hosts discussions on timely issues facing the legal profession and society. Today's panel will discuss lessons from high-profile acquittal. This event has been approved for 1 hour of CLE credit by the Texas State Bar. If you're joining us via Zoom, you'll receive an email after this event with information about claiming your credit. If you happen to be joining us by phone, please let us know by sending an email to Center for Women in Law, that's all one word, at law.utexas.edu. And for those of you joining us for the very first time, the Center for Women in Law is a national resource and champion for women lawyers, generating lasting change within the legal profession. So let's go ahead and start today's panel discussion. I'd like to introduce today's moderator, Cheryl Scarboro. Cheryl is a partner in the DC office of Simpson Thacher and Bartlett, where she is a member of the firm's government and internal investigations practice. She represents corporations, financial institutions, and individuals in government investigations and other regulatory enforcement proceedings. She joined the firm after 19 years with the SEC, where she served as Associate Director of the Division of Enforcement and the first chief of the SEC's FCPA unit. So welcome, Cheryl.
Thank you very much. It's a pleasure to be here. I will just start briefly by introducing our two panelists, and we will get going with what I'm sure is going to be a very interesting discussion. With me today are David Gerger and Ashlee Martin. David is the founder of Gerger, Hennessy & Martin in Houston and has a national practice in criminal law. He graduated from Yale College and the University of Texas Law School and clerked for 2 federal judges and served as assistant federal public defender before starting private practice. The biggest victory is quietly stopping an indictment, but his publicized cases include defending the CFO of Enron, winning acquittal in the BP Deepwater Horizon blowout trial, and this year, with Ashlee Martin, as we'll discuss, the acquittal in the Boeing 737 MAX criminal trial. He's a frequent teacher and speaker on criminal law and a fellow of the American College of Trial Lawyers and the American Board of Criminal Lawyers. Ashlee Martin is also a partner at Gerger, Hennessy & Martin. She's an experienced trial lawyer and former federal prosecutor who currently defends individuals and companies and civil proceedings in federal and state court. She's been named Best Lawyers Ones to Watch in 2020 and 2021 and 2022, the National Bar Association's 40 Under 40, and the National Bar Association's Best Advocate of the Year for 2022. It's a pleasure to have both of you here today. And with that, I think I'll start by just giving a brief overview of what we're going to be talking about today, which is a matter that both Ashlee and David will go into some detail about that they've litigated successfully very recently. As an overview, in 2018 and 2019, 2 Boeing airplanes crashed, killing approximately 346 people. In January 2021, Boeing entered into an agreement with the Department of Justice, a deferred prosecution agreement, to resolve criminal investigation into them. The gist of the charge was conspiracy to defraud the Federal Aviation Administration's Aircraft Evaluation Group in connection with their evaluation of the planes at issue here, Boeing 737 MAX airplane. In connection with the resolution, Boeing paid $243 million. As Boeing admitted in court documents, Boeing, through 2 of its technical pilots, allegedly deceived the FAA about an important aircraft part, which you'll hear us discuss today, called the Maneuvering Characteristics Augmentation System, or MCAS. And this allegedly impacted the flight control system of the Boeing airplanes. It was alleged that because of the deception, a key document published by the FAA and in turn put in airplane manuals and pilot training materials lacked information, vital information about the MCAS system. Mark Forner was Boeing's chief technical pilot, a senior position responsible for the company's interaction with the FAA. And his job was to ensure that flight simulators behaved like the plane did and to recommend to the FAA training pilots that would need and what should go into flight manuals. In 2021, Mr. Forner was indicted and charged with 6 counts of fraud, each with a maximum of 20 years in prison. 2 of those counts were dismissed before the trial. The basis of the charges was the allegation that Mr. Forner had deceived Boeing's customers by not telling them that he had provided false and misleading information to the FAA. After a trial that lasted less than 4 days, Mr. Forner was acquitted of all charges, and the jury reached the decision after only 2 hours of deliberation. So just to kick this off, my first question, Ashlee and David, is this. Your client, Mr. Forner, was a mid-level employee at Boeing and the only individual charged in the matter. Some have called him a scapegoat. What was your strategy in terms of how you characterized them, and how did that impact the way that you set this case up for trial?
Well, thanks, Cheryl, and thanks for having us. I'll take this question, David, and please add to it. But I want to set some context here, because you talked about him being a scapegoat in this, and I'm sure as David will talk, we never really used that term within the trial, but that was sort of the theme that we took. But let me set a little bit of the context and what we were facing, because you talked about these 2 crashes that happened. One was Lion Air crash in October 2018. And that was sort of off the waters of Indonesia, 13 minutes after takeoff. 189 people were killed in that crash. And then only 5 months later, the Ethiopian Airlines crash in March of 2019. And that was so 6 minutes after takeoff, 157 people. So as you said, 346 people died within 2 crashes in 5 months. And that initiated congressional investigations, civil suits, and then as long as the criminal investigation that we were involved in. So this was a massive, massive effort on different fronts. And it all came down to it. Seemingly all of these things started to focus on our client, who, as you said, was a mid-level employee at Boeing, for his alleged refusal to provide information about a software that was triggered in both of these crashes, MCAS. And to us, in just looking at the evidence and looking sort of the scale of these tragedies, it seemed unlikely that one person, and I think he made maybe $160,000 a year, would be responsible for these massive failures of the crashes here. And in order to really understand his part in all of this, we got to understand the fact that this was a brand new plane. Right. This was a new iteration of the 737 MAX. And I'll explain really quickly what his role was in that process. But when you have a new iteration of a plane, and in this case, the MAX, there has to be sort of a review of any of the differences between the new plane and the old plane. And our client, Mark Forner, was responsible for identifying some of these differences in order to determine if the differences needed training of a certain level. And what the FAA and the government charged him with essentially was that because he wanted to get the lowest level of training possible, he withheld information about a change related to MCAS that they would then say resulted in a lack of training for these pilots, who then ended up crashing the planes. But David, you want to talk a little bit more about, after setting that context, of how we formulated the defense of the scapegoat without saying it?
Well, thank you. And thank you, Cheryl. I think a lot of people, when they're confronted with this case, say he's a scapegoat. And, that goes back to, of course, Leviticus, where the scapegoat in Leviticus is really an innocent goat who is cast out of society and blamed for the sins of others. But in modern usage, I'm always a little bit afraid of that term, because some people think it means you're guilty, but so are other people, and you're just being blamed for it, And we didn't believe that our client was guilty, because we didn't believe he learned about this piece of information that he was accused of withholding at all. But the way to prove you're a scapegoat is not to use the word scapegoat. It's simply to show the facts that your client is a small piece of a big puzzle, a big corporate and regulatory, and in this case, international failure that he didn't cause. And as Ashlee mentioned, he was not highly compensated. He did not receive a big profit because of some alleged criminality. He wasn't an executive. He wasn't even at the management level of the company. And I think that, by showing what he did know and what he didn't know, the sort of scapegoat idea just automatically comes in. Cheryl, you mentioned the BP case. There were a lot of similarities. And in BP, the government even filed a motion that we should not use the word scapegoat, which we agreed to, because you don't have to use the word if you show the facts. He's a small part of a big failure.
Yeah, very, very interesting. And it leads me to another question about your trial strategy here. So I understand that you only called one witness. It seems like a very tight, very, very short trial, very narrowly focused. Can you talk a little bit more about your strategy? Is it related to putting on your defense?
Well, this is a criminal case. And so in a criminal case, the burden lies with the government, sort of the highest burden there is, which is beyond a reasonable doubt. And so every day of the trial, we're assessing, are they meeting their burden and have they met their burden? And at the end of their case, we really felt there was only maybe one issue that we needed to answer that the jury may have a question about. And that was sort of, what did he do after he saw, and we'll have to give a little bit more context about this, but after he saw a glitch in a simulator and he made a comment that became the theme of this trial, which is, after he saw this sort of glitch in the simulator, he said, I guess I lied to the regulators unknowingly. And the government used that to say, okay, but at that point, he knew about this change because the simulator was reflecting a change in the software. So he knew and he didn't do anything. So we needed to address that. And so we were able to call one witness that says, okay, after you find a glitch in the simulator, what do you do? What is a normal course to do? And that is to make a discrepancy report. And we had someone explain that's what he did. He followed the course when you think there's something wrong with the simulator and not necessarily something wrong with the plane. But it really was a day-to-day assessment of, do we think the government has met their burden? And if they have not, we don't necessarily need to do a lot more than that.
Yeah, the experts in juries tell you that juries make up their mind quickly. And so, in a criminal case, the government goes first. And so if we're waiting till our case to make points, it's too late. The jury's already made up their mind, and that's that's the risk anyway. And that's going to color how they receive any evidence. So this was an unusual case because we had subpoenaed 10 or 15 witnesses to trial. So we actually were planning to put on a very extensive defense. The government made the smart decision that the government was going to put on a really tight, narrow case. And it made a lot of the points that we wanted to make irrelevant or awkward. We wanted to show how big the failure was. And Ashlee's going to talk about this. Are the crashes relevant? And the government wisely put on such a narrow case that a lot of our evidence would have seemed out of place. And as Ashlee said, there was one point we had to prove, and that's the one witness we called, because we had scored enough points Now, if it hadn't worked out, we wouldn't be on your program. And the concession would be those dummies had all these good witnesses to call, and we didn't call them. There was an FAA employee who had written a paper criticizing the indictment and calling our client a scapegoat. Why didn't we call that? Experienced FAA person, and this gets so personal. Some criminal lawyers want to put on a big case. Others don't want to put on anything, and we fall more into that category. We had to call one witness.
So backing up for a minute, which I think might be interesting for the audience, it seems that this case boiled down to two pieces of what could have been pretty damaging evidence, right? You have what Ashlee referred to, which relates to the chat and what your client said there, and then also an alleged phone call with the superior. So can you talk a little bit more about those two, which could have been really terrible pieces of so-called evidence, and how you managed, how you dealt with them?
Ashlee, pick one and I'll do the other.
I'll take the chat and you can take the phone call. So the chat I referenced earlier was sort of an instant message chat between our client and his colleague. They both were technical pilots in the technical group. So they were responsible for determining what training, if any, that new pilots would need for this new plane. And on one night, after being in a simulator, not an actual plane, it's kind of like a robot-looking machine that is supposed to mimic the plane. He's writing to his colleague and his friend. He talks about, drinking Grey Goose while he's on the computer. And he writes these words, which sort of the government paraded over and over and over again. He says, "Oh, shocker alert, MCAS is now active down to Mach 0.2. Now, Mach 0.2 is the change in MCAS that we say he never knew about. And the government says, well, he knows then and should have told the FAA that the speed change, that MCAS is now active at a lower speed, Mach 0.2.
Nash, to interrupt for a second, just because I didn't know any of this, but I guess the impact of that potentially is that the nose of the plane could go down during takeoff and landing as opposed to at a higher speed, right? And that was the relevant.
So MCAS is a software that's put into the plane essentially during certification maneuvers, or things we'll never see. So when a plane is at a high angle of attack like this, and the initial version of MCAS is high angle of attack, high speed, that this software will automatically push the nose down without the pilot doing anything to stop the plane from going into a stall. There were some complications with that high speed MCAS, so that they had to lower the speed so that MCAS could activate even in low speeds, but still high angle of attack. And what happened in both of these crashes, I mentioned the first one was 6 minutes and 13 minutes after takeoff. Those were lower speeds. And so MCAS activated when it should not have, pressing the nose down and causing those crashes. So he's saying in this chat, MCAS is now active down to Mach 0.2. It's running rampant in the sim on me. At least that's what Vince thinks is happening. So he's saying, this is what Vince, another simulator person, is saying is happening when I'm seeing this in the sim. He's saying it's MCAS down to Mach 0.2. And then there's a little bit of exchange, and then our client says, so I basically lied to the regulators unknowingly. And they use this chat over and over again to say, okay, yes, MCAS had changed before this. This was in November. I think it changed in March. So March to November, yes, it changed. And Mark Forner, our client, did not know. But the government is saying now he knows. He writes it himself in black and white. He says it's down to 0.2. He knows. And he never communicates that change to the FAA or to Boeing to say this is a difference in the plane. And they use that to show his knowledge that he now knows. And then the fact that he did not communicate that, he concealed that. So, this was a big piece of, okay, our stance is that he didn't know. How do we present that without presenting any witnesses of our own? Because we only presented one person. So how do we sort of present that defense through their witnesses that he did not know? And David talked a lot about this. There were a lot of things about that plane that our client did not know of. And we were able to show through their witnesses, through communications, through emails, that even that sometimes the FAA witness mentioned she knew more about the plane than our client did. We were able to show official engineering documents that even after this time were communicated to our client, and they did not have the change in it. We were able to just sort of show that it was reasonable for our client to believe that Vince didn't know what he was talking about and that it had not changed, because he doesn't get his information from Vince. He's a simulator guy. He gets his information from the engineering group, who never communicated to him of this change. And so we had to show that that it was reasonable for him not to actually know, even though he writes it, in black and white, that there was so many other facts and evidence that it was reasonable to show that maybe, he actually didn't know or understand. And not to mention, what did he do after he wrote this? Well, he wrote in the discrepancy report what he was seeing in the simulator. They looked at it and they said, that was a glitch. There's nothing wrong. There's nothing wrong with the simulator. And he went on about his merry way like he normally does. And so given all of that, plus Boeing did communicate to the FAA, not our client, but other Boeing engineers communicated to the FAA about this change. We were able to show that, it's likely that our client just wasn't in the loop, and other higher up engineers were, and they did communicate to the FAA, and the FAA didn't do anything with the information.
Yeah, and to amplify that, as Ashlee said, we had these documents, official documents that were sent to our client showing no change, right? So he's being given incomplete or old or wrong information through official channels. And, think about, Cheryl, if 6 FBI agents could look through every text, chat, email, memo, diary, anything you've ever written, to look for one phrase out of context to look bad. And I think that the jury understood that this chat was part of a much bigger context, written at night to a friend, not an official chain of communication. And they credited the fact that he'd been given officially the wrong information. And as Ashlee said, others at the FAA knew anyway about the change. The phone call was also serious because after this chat was written, a witness testifies. The witness is a senior executive that one day Mark Forner calls to ask if the software has changed. And this very high executive says, yes, it has. And here's how. So that's knowledge again to our client. Well, we figured that if such a phone call really happened that way, there'd be some record of it, a memo, a note, a follow-up, that the boss would say something like to other people, make sure that you send the right documents to our chief technical pilot, or how come he doesn't know? And there was nothing, not even a phone bill showing that the call happened. And I think that that was enough to say maybe this phone call wasn't this dramatic phone call that the executive can remember from 5 years ago. Really might not have happened that way, because if it were so important, there'd be some record of it. We also got very lucky in cross-examination. We asked the man if he could remember other phone calls with our client that we had documentation of, and he could not. So we went through those to the end point being, let's get this straight. You cannot remember the phone calls that are documented. But you can remember the one phone call that is not documented. And it didn't make sense. And the premise behind it was, he's maybe he's doing his best to help the government in cooperation. But anyway.
And David also, he cross-examined that engineer, and he did a great job on this, because the line of questioning that that I'm going to talk about in a second, it sort of accomplished two birds, one stone. One, it kind of showed his incentive, because he was a highly compensated executive, to really be on the company's side. And two, it showed his lack of memory. And that was, and I don't know if David was intending to do this, but it sort of played out this way, and he ran with it. He was trying to show how much over the years that this was relevant, how much this executive made, and it increased, exponentially every year. And so instead of telling the executive on cross-examination, oftentimes we say we put the answer in our questions, right? But in this sense, he said, well, how much did you make in 2015? And the executive couldn't remember. He didn't know. He didn't know how much he made. And then it's okay, well, how about 2016? How about 2017? And each year he could not remember how much money he made, which was over $1 million at some points. And here you have 12 people, regular folks in a Fort Worth jury, and they're looking at him like, you can't even remember how much money you make every year, but you remember a 2-minute phone call that happened 5 years ago that there's no record of. And so he really lost a lot of credibility with that.
Well, one other thing that I wanted to ask you about is you two really made an incredible team. I want to know how you divided some things up. Like, for instance, was there any particular strategy in terms of who took the opening, who took the closing, who crossed different witnesses? Can you talk a little bit about that?
David, you take that.
Yes. Well, we had an incredible team. I mean, and you couldn't pull off a trial like this without a team who's split up responsibilities. So I did the opening and the one cross-examination that Ashlee mentioned. Our co-counsel in the Dallas-Fort Worth area did the voir dire, which is what we call it in Texas. I don't know what you call it up east. And the closing statement, Jeff Kearney, just a beautiful communicator. And to the all-important witness from the FAA, who was a woman, Ashlee cross-examined her. And I don't know, much tougher, than I would have. That's because Ashlee's tougher than I am. But I think that there was some. Ashlee talked about that. I mean, you and she went round and round.
Can you talk about that in particular? I'm also curious. I know that we're talking to a group where one of the main themes here is women and female lawyers. I'm curious as to whether there was any strategy in having you be the one to ask the tough questions of a woman, and whether that you thought that might play better to the jury. Was that a factor at all? Other than, of course, you're clearly incredibly able to question anybody. But if there's anything that goes into this that's different, and when it's a jury, is you do have to take into account the makeup of the jury, their sensibilities, and how they might react to, how you're treating different witnesses. Was that at all a factor in this decision?
It was. And I had the agent, who was also a man. He was a man, and I had the FAA witness, who was a woman, but she was kind of the most important, I think, witness to the government's case. And it was important because she, in some ways, she was playing, I don't want to say playing, but she was presenting herself as a victim in some ways. And she was also very obstinate. And so the optics of David or Jeff having to really kind of go hard at her as a woman, especially if she was going to sort of, we didn't know how she was going to come across, if she was going to be soft-spoken or be sort of sweet. We thought a woman to a woman would just take out the gender issue altogether. And really, they could just focus on the substance of what we were saying. It turns out she was extremely obstinate. She wouldn't even give me, if I asked her birth date, she would say, what do you want to know that for? She didn't give me anything easily. So we had to go, at one point, you could hear a pin drop in the courtroom, and the judge was going like this. His head was like ping pong back and forth between she and I, because it became a real battle with us. So it worked out because I don't know that David would have necessarily wanted to get there with her. And we all have different styles. Like, as you can see, David's very polished and gentlemanly and sort of, they call it the Gerger honey. And I'm a little bit more direct and blunt and sort of get to the point. And then Jeff is just sort of this very senior statesman, like, can really sort of connect with the jury. So we all had very different styles. And it did come into play on which roles we would take.
Interesting. So I do have one more substantive question, but then I also just want to pivot and talk about the makeup of the jury, because that kind of ties in a little bit with what you were talking about before. But before that, my substantive question has to do with your strategy about mentioning the fact that you had 2 airline crashes here. Can you talk about that decision and what impact you think your decision had on the ultimate result here?
If the emotion for us was being a scapegoat, I mean, the emotion of the whole tragedy is 346 victims and their families. Innocent deaths, terrible. And, you would expect that the government might want to get into that, and we would not. But it turns out that flipped. And although the indictment talks about the crashes, I think the government came to a conclusion that it would make Mark look like even a smaller piece, because this episode we were charged with did not cause the crashes. It didn't contribute to the crashes. And the government didn't want to be seen as blaming Mark for the crashes. So they backed away from that, even superseding the indictment to take the crashes out. And they wanted to put on a very focused trial just about whether there was a false statement made. Now, I will say on the defense side, most of us wanted to exclude the crashes, but this was part of Ashlee's genius. And Ashlee, you should explain how you used these crashes so effectively in the cross-examination of the FAA witness, because Cheryl, understand, this FAA witness was saying this information was withheld from her. We don't think it was because of other communications, but she says it was withheld from her and she should have known about it because that might have made a difference. So Ashlee, take it from there.
Yeah, I thought the crashes were very helpful to us to bring them into play because of what David says, right? David is saying, and the FAA is saying, if we had known about this change in MCAS, maybe we would have required training. Maybe we would have done something different to save the day here. And what better evidence of what they would have done, but for what they did after the first crash? There were 5 months in between the first crash and the second crash. They certainly knew that MCAS was now active in lower speeds because the crash happened shortly after takeoff. So if they're saying, and had we known this, we would have done so much. Okay, well, what did you do, FAA, after you learned after the first crash? And the answer is nothing. The only thing they did was remind the pilots of the training they've already received. It's called a runaway stabilizer. You flip a switch and say, that's all you should do if something like this happens on the plane. They didn't do anything to change the training of the pilots for this new MCAS, which is what we were saying all along, is that no one thought there was new training needed for this MCAS.
That was very, very interesting. So I guess you risked this having another emotional impact on the jury, right? Where they might have, they might have, listening to this and feeling the emotional impact of what had ultimately happened here, which is, hundreds of people had died. They might well have wanted to pin the blame on someone. And since Mark was that person, they could have decided to blame it on him.
Yes,
Well,
but there had been so much media. And in fact, even on the eve of trial, a Netflix documentary that was the #1 Netflix show was a movie about this tragedy. So they knew.
right.
And Ashlee did it with a very light touch,
Right. I don't think we ever used the word crash. We said incident. But that's the other point, Cheryl, is that, when you're doing a trial, this is real people in the real world. Like, we couldn't imagine that they're in a vacuum, that they don't know about these crashes. They knew about it. And even if we never said it, they knew why we were there. They knew what this whole thing was about and what it came about. So I didn't think it made any sense to pretend that they didn't know. So if we don't say anything, they won't think about it. No, the first thing people think about when they think about planes is crashing.
Sure.
Afraid of flying. So I didn't think we could avoid that. And in fact, we needed to use it to our advantage.
Mm-hmm. So that kind of dovetails, Ashlee, with what I wanted to talk about next, which is the makeup of the jury. Can you talk a bit about the makeup of the jury, any strategies you had going in terms of jury selection, and if at all, how you think the makeup of the jury impacted the result?
Well, I think we can't take any credit for the jury makeup. We hired sort of like the best jury consultants that there is, Robert Hirschhorn, and really just let him come in and do his thing. I don't even think David paid any attention when we were selecting the jury, because he's sort of the best.
Okay.
But I could tell what it ended up making. It's interesting. We had 11 white men and 1 Black woman. And she ended up being the foreperson. And our jury consultant said she was going to be the foreperson. And we also, I think, included even a pilot, which I thought we would have taken. I just knew he was going to exclude, because you don't want an expert back there that knows about flying. But he says, no, pilots will get this. They will understand our client's job and his role in all of this. And so one of the jurors, had a pilot's license and had experience flying planes. So it was interesting that that at the end of the day, the one sort of minority on the jury became the leader of the jury. And, they sort of followed her suit, and they were out for 2 hours. Not even 2 hours, maybe an hour and a half with the verdict. They just really did not believe the government had met the burden.
One other thing that you both talked about, this case was all over the media. Lots of public scrutiny, lots of negative publicity, even on the eve of trial. What was your strategy in terms of dealing with that? Did you engage with the media? Did you have a particular strategy in terms of how to deal with what must have been a very pressure-filled situation?
Maybe 2 answers. I'm not very comfortable with the media. And we got hundreds of calls in the months leading up to the trial, and certainly during the trial. And the most we did was once or twice put out a written 1 or 2 sentence statement. We had a statement after leaving the courthouse at our very first appearance, and that's it. And in a case, we did talk to some media consultants about what it would take to try to deal with the media. And we ultimately decided we had to get ready for trial. We couldn't be media personalities for this, and we're not good at it. So that was one thing. And, we would see leaks in the press, as we often do in criminal cases, and didn't combat those. So we really did not play in the media sphere. And that's because we always come down to the only people we care about are the 12 jurors and the judge. And everyone in the courthouse is important, everyone. But from the bailiff to the clerk and the court report, everybody is important, but the jury and the judge. So what did we do? We asked for a jury, more voir dire and a jury questionnaire. And Judge O'Connor allowed a jury questionnaire. Both sides contributed whatever we wanted. The judge approved it. He brought the jury in 3 days before the jury selection and had all the potential jurors fill out this questionnaire and gave it to us 2 days before trial and to the government. And that was very important, in learning what exposure jurors had to the media and what preconceived ideas they had about flying and about Boeing and about this case. And that's really how we dealt with the media, was to say to the judge, we need a questionnaire. And he was open to it.
Right.
And attorney voir dire. He allowed the attorneys to ask questions of the jury and even bring in jurors one by one based on their answers. So that was very important.
If there's anything you would have done differently, I mean, given your amazing result, I don't know what else you think of, but is there anything you would have done differently?
I think if we had lost, then we'd have a long list of things we've done differently. But given we got the acquittal, I don't think I'd change anything. You, David?
Just let Ashlee do it all. Less stress.
The second question has to do more with the discovery process. And I did have a small question about that too. And that is that I know that we had talked before about the massive number of documents and the time crunch you were under in terms of the review. I think at one point you mentioned you had 60 or 67 million pages of documents to review, and you had about 150 days or so to do it. Can you talk about how you got yourself through that massive amount of material and any tips you might have for other people dealing with something like that?
I'll give some context on that, but we did have 67 million pages, 16 million documents. We were indicted in October of 2021. And I think we had 155 days before trial. We were set for trial within 30 days of being indicted and then asked for a continuance, which the government opposed. After giving us 67 million pages, they opposed the continuance. And the judge would only grant us 30 days each time. Sorry, they're working on the roof or something here. But, and so, as David brilliantly put together a great team of, I think we had 3 different law firms helping us. Someone was helping us with research and briefing. Another person was helping us with doc review. We just had to sort of had an all hands on deck approach to this. But it will show you sort of, too, there was some strategy behind the government doing that. They intentionally were opposing our continuance request, one, because they thought it handicapped us not to have more time to look at the documents, and also that they thought the judge would get upset if they agreed to a continuance in this case. But David, you want to talk more about? I think someone asked about the cost of going to trial since he was a mid-level employee.
Well, very few people have the courage and the resources to defend themselves. But the only thing I would say about this virtual law firm we put together of several firms, Cooper Kirk with research, Zuckerman helping us with interesting legal issues, how do we get access to even more information at the FAA than we had, and a wonderful law firm helping us with document review. It's been a dream of mine to be able to put a team together that had no ego in anything other than making the other firm look good and helping win the cause. And we just were able to pick people, even famous lawyers and lawyers at all level in these other firms, who we just rolled up our sleeves. Everybody dove in and did everything. And of course, as a technical matter, what you do is you put all these documents in a database and you run word searches on them. But that's harder than it sounds. And we just had an amazing group of people working on it. And everybody was just dedicated to do it and not try to have sharp elbows. So that's why we were able to get through it.
Well, part of the question also related to the fact that you had a client who was a mid-level employee, didn't have a lot of money, lots of resources. Did that at all play into the decision to take, it's never easy and it's never cheap to take a case to trial. Did that at all have any impact on the decision, and how did you manage that? It's part of the question someone has asked. And, I think part of the question also is what the decision-making process was as it related to plea offers along the way as well.
Well, sometimes you're blessed with a client who is going to defend himself to pursue the truth. And so there wasn't much for plea offers. But, without getting too much into the costs, sometimes companies are willing to support their employees in the costs of a defense. And they should do that unless the person, did something really over the top or stole from the company or did something. And in a criminal case, we wouldn't take the view that well, if we don't have resources, we just can't do the case. But you can go to the court to apply for funds. Even if your client's been able to put together some amount of money to hire a lawyer, if the client then can't afford to have a database and look through the discovery, and you should go to the judge ex parte and ask the judge to provide funds through the Criminal Justice Act for that person to be able to defend himself. But and we've done that in cases, and sometimes the circuit cuts our bill at the end. But there's a long tradition in criminal law of not being paid, but you get paid enough on other things.
Well, I have one final sort of wrap-up question for both of you. I think this has been incredibly interesting, and I just want to make sure I leave time in case there are other questions that anyone in the audience has. So my overarching kind of last question is, this applies to any trial, but I guess in this one even more so, given the high stakes nature of it. I understand that there were, if you did the math, 20-year, max of 20 years for each of the counts for your client, lots of media scrutiny and emotions were running high. How do you manage? Maybe you don't get nervous at all. You're both seasoned litigators, but do you still get nervous when you go to trial? And if so, how do you deal with that?
I don't know if this is believable, but it's true. I really don't get nervous. I love it so much. I'm really excited about it. And maybe I'll have a few nerves, like when we're sitting in the chair before, it starts. But once it starts and we're up and we're going, it's like, I feel like I'm in a zone and just really feel comfortable. So for me, I don't know if David has a different answer. It's not so much nerve-wracking. It's more so like excitement, and I'm ready to go and get it going. But I look forward to trial.
Ashlee knows I have a different answer to that. I am so nervous before every witness, before every trial. I can't sleep. I can't sleep now about next year's trial. And I am nervous, and worried that something terrible is going to happen to my client. And of course, that I'm going to look bad. And so, in fact, before opening statement, Ashlee knows this. I called a meeting and gave the opening statement the night before, and it was terrible. And Ashlee changed it at the last minute. And
it wasn't terrible.
But I will say this, because there are people who look like Ashlee looks and are so calm. I was actually consulting with a professor of mine, Michael Tiger, before this trial. And to my generation, I'm 62. Mike Tiger is, on an Olympus. He is the brilliant advocate, of my generation and the generation ahead of me, and still super active. And I said, Professor Tiger, you look so cool. How is that possible? And he said, David, lawyers are bundles of ego suspended over uncertainty. He probably said something in Latin and then French. And then he said that. And then he said, have you seen a duck? And I'm telling this to all young lawyers I meet. I said, yes, I've seen a duck. He said, a duck swimming upstream in the river. Above the water looks majestic and calm. And below the water, its feet are paddling as fast as it can just to stay afloat and in the current. And that's how I am. And I said, wow, if Mike Tiger says that, then I felt a lot better.
If you can gather, David and I have very different personalities, but they complement each other in certain ways. But I will say, if I'm nervous, it's because I'm not prepared. For me, David's the complete opposite. But like, if I'm nervous, it's because I feel like I'm not completely prepared. But other than that, I'm ready to go.
Second question was whether this trial was recorded and whether there was a way for them to get access to a recording of it.
Well, there's no recordings. There's transcripts of every federal trial, but there's no television recording that I've ever seen in a federal courtroom, and there's no audio recording.
But I think if you go on the docket, if you look up the docket, this is in the Northern District of Texas, you should be able to get a transcript.
I'm sure that a lot of the nuances and all of that aren't quite picked up in a transcript, but it's certainly better than nothing. Does anyone else have any questions? We have a couple more minutes. I know it's a little harder when you have to do it through chat, but we are looking.
I will say, though, this is what I'm finding over and over again. There's a tragedy of what they call the trial penalty, right? Our client had the resolve to really sort of stick to it and go through all of the pressure and the scrutiny and all of that to go to trial. But there's so many people, everyday people, who don't have the resources, who don't have the support, who can't sort of withstand, losing their job and everything else, and being sort of this public enemy number one, to go to trial and really reclaim their innocence. And it's a really sad thing that so many people do have to take pleas just because they're afraid of exercising their rights in a trial. So to me, it's one of the biggest issues facing our criminal justice system, and we should, as lawyers and in this community, try to figure out a resolution to that.
Right.
Yeah, to the question about plea bargain in general, we can say what Ashlee said. The trial penalty refers to what we all know, but a recent study also largely led by former Judge John Gleeson for the National Association of Criminal Defense Lawyers, and other groups have studied this. That the government comes to people and says, well, you're facing 20 years, but if you'll take this deal, you can get 2. And when that gap gets too wide, then innocent people will decide they have no choice.
Oh, sure. Another question we've gotten just a second ago was, obviously I talked at the beginning about the Boeing DPA and we've talked about your client, but the question is, were there any other criminal charges in connection with the Boeing crashes?
Nope.
No, this was it.
Okay. And I see another question wanting to know whether the case was heard in the Northern District.
Yes.
Northern District of Texas, Fort Worth Division. And that was a very interesting choice, if I can elaborate on that. This case was not indicted as a false statement to the FAA. It was indicted as under a theory called the right to control theory of wire fraud, which is now in the Supreme Court, cert granted. And the theory is that Boeing had not told the truth to its own customers, like American Airlines located in Fort Worth, Southwest Airlines in Dallas, Fort Worth, about the certification of the plane, having not had all the facts presented. And so that's why it was brought in Fort Worth. And the theory being that if you hide relevant information from a customer, that is wire fraud. And that's a very controversial theory of fraud. We briefed it a lot, whether that really constitutes wire fraud or not. And the government, had requested a jury instruction on that theory. And Judge O'Connor did not give the jury instruction that the government asked for. And of course, we were cheering until we realized, that would have been a good appeal point for us had we lost. So he really, the effect of that was to take away a big appeal point we would have had.
One last question here. How do you counsel your client and their families through the anxiety of a possible prison sentence, especially as the government presents its case?
That is probably the hardest thing I've found about being a defense attorney. I was a prosecutor before joining up with David, and we didn't really have clients. You represented the government. You didn't have to deal with the emotion of that. And you didn't really get to know the defendants or on the folks on the other side. So it was a little bit separate, but really getting to know your clients, having to walk them through this day by day, counsel them on the risk and what that means has been, I think, the really the most difficult part about this job. And so I try to say, they really have to take it day by day. If they try to look too far in the future, it really just can really mess up their heads a little bit, and just anxiety can take over. So we have to just deal with what's in front of us each day with them. And they go on roller coasters just like any of us would. Sometimes they're really confident and ready to go and let's go get them. And then sometimes they're like, what am I going to do? I'm going to jail. And I think, and I don't think our client would care, but, literally, I think after we closed and everything was over, he sort of was on that ride and was like, we're going to lose. Like after everything was done, that's sort of how he felt. And it's just an emotional roller coaster. And I don't know that I've honed it yet. David's been doing this a lot longer than me, but it's one of the challenges of this job to really try to walk with someone as they're going through their darkest times.
It's a very rich part of the job, frankly, because a lot of it, it's sort of there, but for the grace of God go I sometimes. But I think what clients want to know is that you're fighting for them. And so you be honest about the possibilities and you show them that you're fighting for them. And that's what you can do.
Well, David, Ashlee, I know we've run out of time. I just want to say congratulations again on a tremendous win. And thank you so much for what I incredibly informative panel. Really appreciate you taking the time to talk to us.
Thank you.
Thank you.
Thank you, everyone. Thanks so much, Cheryl and Ashlee and David, for a fascinating discussion. I wanted to thank everyone who joined us here today as well. There was a question about the CLE. If you're joining us via Zoom, you will get an email with that CLE number and how to claim credit. There was also a question about how to see a recording of this video, which will be up on our website. And I think we have in the chat a link to our website where you can learn more about our upcoming events and how to support our work here at the Center for Women in Law. So thank you for joining us today. I hope you'll join us again on October 6th for the latest in our Power Lunch series with Chief Justice Rebecca Martinez of the Texas Fourth Court of Appeals and Dolores Atencio, founder of the Luminarias de la Ley, Luminaries of the Law Project. Be sure to follow us on social media and check out our website for more information. I look forward to seeing you all again soon. Thanks so much.